Hello, we have with us today the Honorable Michelle Harner, bankruptcy judge for the District of Maryland. Our subject today is Subchapter 5, and Judge Harner is a perfect person to be talking about that because her strong history and background in the creation and development of the Subchapter 5 law. For example, back in the 2012 to 2014 era, Judge Harner served as reporter for the Commission on the Study of Chapter 11, which focused extensively on smaller businesses. And then this past year, she served as co-chair of the Subchapter 5 Task Force. And so, Judge, it's great to have you here to talk about Subchapter 5.
Well, thank you for having me. I'm honored to be here and be talking about this really important subject. As you know, I love talking Sub 5.
Well, great. But before we dive into that subject, I've got to ask this. What does a reporter for a commission do?
So it's a great question. I will say typically the reporter for any commission or committee is an academic. I'm not sure why that has evolved in that fashion, but it's usually an academic. And so when I was the reporter to the commission to study the reform of Chapter 11, I was on faculty at Maryland Law School and was just thrilled to be asked. I remember the day that Sam Giordano called me up and asked if I'd be willing to jump in and do this. And I said, absolutely. And so as reporter, as you can probably tell from working with Professor Sickler, who was the reporter for our Sub 5 task force, the reporter does a little bit of everything. So the reporter is responsible for recording all of the deliberations of the commission, all of the meetings so with the commission, we had advisory committees that helped the commission do its research and work. So I recorded the meetings and recommendations of all the advisory committees with the help of their chairs, who were tremendous. And then I also recorded all of the hearings we had. We had 16 hearings with the commission. With the Subchapter 5 task force, we only had 7 because we were working in a much more compressed time frame. So you do all the recording to document what the commission's doing. You then participate in the deliberations really as a facilitator to keep the dialogue going and headed in a direction. Because as you know, when you get a lot of really talented people in one room, the conversation can go just about anywhere. Yeah. So keeping the group focused and on mission was certainly part of the reporter's duties. And then I was in charge of conducting all of the research or coordinating the research with colleagues or the advisory committees. And finally, probably the biggest task was drafting the final report for the commissioners to review, mark up, and work from. And so I brought exhibits. So this was the Chapter 11 final report. And
wow, that's thick.
Yeah, it was a thick one. I think we were over 400 pages.
And
yeah.
You're the one that wrote that.
I did the first draft, and I have to say, the commissioners were great. As you know, it takes a lot of time to review a final report, and I would give them drafts, very much like Professor Sickler did with us, one section at a time, and they would review it, and I would get comments back from everyone. And that was a little like when you're an associate in a law firm, and one partner gives you this comment, and another partner gives you the completely contradictory comment, and you have to figure out how to reconcile them. So once the first draft was done, it was various iterations to incorporate everyone's thoughts. So although I did the first draft, I really think of it as being kind of the commission's work product, and I'm very proud to have been part of it.
Yeah. So I would translate it as the reporter does all the hard work. Yeah. Okay. You don't have to agree with that, but.
Well, I will say Professor Sickler, as you know, certainly did all the hard work for the Sub 5 task force. She was tremendous, and I have to give her huge shouts out. So.
All right. Now to the Subchapter 5 substance. So
can I bring this one in? So there's
go ahead.
And here's the Subchapter 5 task force report. I have all these reports, which I will tell you are truly great references. I refer to them both. And before getting on this discussion, we were talking about liking paper copies. I keep my paper copies on my desk because even though they're available online, and even though the ABI with our most recent task force report, they've made it user-friendly now. So you can click on links and it jumps you ahead. I still prefer the paper. So I have them both.
Well, very good. All right, now to the Subchapter 5. So first question, what effect did the work of the Commission for the Study of Chapter 11 have toward the creation of Subchapter 5?
So that's a great question. And I will tell you, as I mentioned, the Chapter 11 Commission had over 16 field hearings, and we took a lot of testimony, and we accepted written submissions as well. And one of the key findings we took away from all of those public hearings was the following, and I'm just going to read from the report so I get it right. It says, second, the witnesses who testified on issues relating to small and medium-sized enterprises generally opine that Chapter 11 no longer works for these companies. Witnesses cited cost and procedural obstacles as common barriers and encouraged us to consider reform. And so it was the testimony of witnesses that really got the commission thinking about what they called SMEs, small and medium-sized enterprises. Because I will tell you at the outset, it wasn't necessarily on the commission's radar. They were focused on traditional 11s, what was going on in the general Chapter 11 landscape. And it was only through the testimony and contributions of witnesses that the issue came to the forefront. And so there's a whole section in the commission report on SMEs and proposed recommendations. But that said, Don, I have to take a step back and say that when I think of small business bankruptcies, I think of Tom Small, right? Judge Small, who really was one of the early proponents for doing something different for small businesses. He wrote a paper to the National Bankruptcy Review Commission in 1996. He, through the National Bankruptcy Conference, put together a proposal for a new chapter on small business bankruptcies, I think in 2010. And it was actually a really wonderful collaboration between the National Bankruptcy Conference using Judge Small's work and the ABI using the commission work that I think pushed through Subchapter 5. So the commission report was kind of the last piece, the last big push that, hey, Congress, you need to do something for our small companies or we're going to lose them. But it was built on prior work that was done by Judge Small and the NBC and others. So I think it's important to recognize everyone who's contributed here, but glad to be a part of it. And certainly, as you know, from talking with our co-task force member, Bob Keach, not only was he a very strong advocate for smaller businesses when he was a co-chair of the Chapter 11 Commission, but continues through the ABI to support and push for positive reform for both small businesses and their stakeholders.
Well, that's fabulous. Yeah, a very, very important thing. A very important thing. So, based on, go ahead to move ahead to the Subchapter 5 task force. And both of these, the commission and the task force, are out of the American Bankruptcy Institute. And based on the past year of task force studies, what do you see as the main benefits of Subchapter 5?
So here I will say it's interesting that both through the Chapter 11 Commission study and then the work we did together on the task force study, the commission recommended things need to move faster, but there needs to be flexibility because sometimes a small company hits a barrier. So we can't do what the old small business provisions did and say, well, after so many days, you're out. One of the witnesses before the commission testified as a conveyor belt to certain death for small businesses. So I think speed is one huge factor that was important to the commission, was important, I think, to those who enacted Subchapter 5, and I think remains important as I think about the study we did with the task force, right? Many people talked about how quickly these cases are moving. So speed, number one, tied to speed is cost control, right? Sometimes a small business couldn't even file a traditional Chapter 11 because they knew at the outset it was going to be too expensive. Or worse yet, they would file and they would die in the chapter because they would just run out of money. There's only so many resources in a small business to support the restructuring. So the commission, the Subchapter 5 task force, and I think Subchapter 5 itself recognizes the need to control costs. So by getting the cases through quicker, by eliminating some steps in a traditional 11 that many thought not necessary, for example, the committee, and not having the costs associated with the committee, its professionals, and maybe some of the litigation that flows from that. You contain your costs better. And so those two things together, I think, have been a huge improvement. Cases getting through quicker, and I think the research shows that most Subchapter 5s are in and out within 180 days. And, when you think about what goes on in any chapter of the bankruptcy code, being able to get in and out in and of itself saves you money. So the speed and the cost savings go hand in hand, are necessary for our small business debtors, benefit their creditors, because the less the small business pays for the restructuring, the more money they have to give to their creditors. And I think is helping these companies survive. The final thing that was important to the commission, and I think is reflected in Subchapter 5, is it just can't be the ability to file a bankruptcy case and get the benefit of the stay. There has to be a real path to reorganization for the small business debtor. And under the traditional 11, the absolute priority rule posed a significant barrier. Companies did not want to file a Chapter 11 case knowing there was likely little possibility of keeping their pre-petition ownership interests because they wouldn't have the resources to satisfy the absolute priority rule. So both the Chapter 11 Commission and then certainly Subchapter 5 itself focused on modifying the absolute priority rule in a way that creditors would still receive recoveries. It's not like the small business owner can kind of take the company away from the creditors. A company owner still has to pay the creditors. I think of it sometimes as the owner, the pre-bankruptcy owner, has to buy back the company from the creditors. But it's done in a different way, a way that's more feasible for a small business owner compared to the traditional 11 and the absolute priority rule, even with the new value exception. So I think those three things were huge in the commission study, are important to Subchapter 5, and I think were reflected in the work the Subchapter 5 task force that we just completed: speed, cost control, and an effective reorganization path.
Very good. And the testimony was that it's working as intended, as Congress intended, right?
It was overwhelming testimony. I love the way that Professor Sickler described it in both the preliminary report the task force did, and then in the final report, that many think Subchapter 5 is the best piece of bankruptcy legislation since the 1978 code, which speaks volumes, right?
Yeah, yeah. So you had mentioned moving on a path to death is what happened before. I referred to it as hospice care for struggling businesses, is what Chapter 11 was before Subchapter 5 came along.
Yeah.
Well, thank you. So then, and for the third question, so we've got some history now, and we've got it's working well. Are there areas that could be improved?
So, I think any piece of legislation always has room for growth and improvement. I will say that with Subchapter 5, and I think we saw some of this together, Don, in the Subchapter 5 task force study, the statute is so new, right? It's only been in effect 4 years, that I am hesitant to say we should start tinkering with it right now, right? Because you don't want unintended consequences from a change that might impact how well the statute's currently working. And it is working. Companies are reorganizing, creditors are getting paid, and although it's not a panacea, it's doing a pretty good job right now. So I would be hesitant to change too much. I think if there is an area that would benefit all through change, it would be to eliminate some of the uncertainty we're still seeing after 4 years in how various provisions of Subchapter 5 are meant to work. And I say that because uncertainty is a cost, right? Both for the debtor and for the creditors. Uncertainty is just an expense item for a business. And so to the extent we can eliminate uncertainty, I think these cases would move through even quicker and even on a smoother track. And one area of uncertainty I think we have right now, or I guess it's not even uncertainty so much as a strategy decision that a debtor has to make, is this what we call in the task force report the silent class, right? When you think of Subchapter 5 being an effective reorganization tool, that suggests the company can actually confirm a Chapter 11 plan. And Subchapter 5 gives a feasible path for small businesses to confirm a plan, but whether that's what we call a consensual plan under Section 1191A or a non-consensual plan under 1191B has a huge impact on the post-confirmation life of the business and its creditors, because one keeps a a Subchapter 5 trustee in place, which has costs to it, and one does not. And so right now, we're seeing some cases that are being deemed non-consensual because a class doesn't vote. And it's not because there's creditors jumping up and down and screaming, this is a terrible plan, I'm not being treated fairly. It's more what I think is creditor apathy, right? You have, creditors in these small business cases that themselves are small businesses. And so they look at the cost and time that might have to go into objecting to a plan, or even for some, they may not know what to do with the ballot when they get it. So they just don't do anything. And it's that lack of engagement that makes some confirmations more difficult than they need to be. And so there again, we're having a full-blown confirmation hearing because I have to treat it as non-consensual under 1191B. And although I always make the debtor go through, its requirements under 1191 and 1129 as applicable, things are more streamlined, as you know, when you're doing an 1191A hearing, because everyone understands up front what's going to happen. When I walk into a contested confirmation hearing under 1191B, there's not that same certainty and sense of agreement among the parties. And so I think there's a cost to that. And then, of course, the fact that the trustee has to stay in place, that you have to pay the trustee to stay in place. As you know, being a trustee, that's not always the place you want to be. And so I would like to see us figure out how to allow cases to confirm under 1191A while still protecting creditors. I want to emphasize, I don't think debtors should be able to run over their creditors and completely, eviscerate their rights. I mean, we try to balance rights in bankruptcy, and it's just as important in Subchapter 5 as it is under any other chapter of the code. So, as you know, in the Subchapter 5 task force, we suggest allowing a debtor to have what's called an 1191A confirmation if they can meet all the creditor protections provided in Section 1191B, showing that the plan is fair and equitable, that they are in fact committing all of their projected disposable income, letting everyone look at their projected disposable income to make sure that's the case, and otherwise satisfying the court that creditors are being treated as they should under the code. And if they can do all that, which is a protection for creditors who aren't showing up, who aren't engaged, we would give the debtor the benefit of confirming a consensual plan, so to speak, or what I would just say 1191A plan. So they get some of the benefits, which would be the immediate discharge, the ability to be their own dispersing agent, and start moving to that post-confirmation stage of operation sooner rather than later.
I remember when I first became aware of this issue, it was like one of the first one or two cases as a trustee I was involved in, and it was coming right down to the end. And I don't remember whether I was talking with the judge in a hearing or with the U.S. trustee or somebody, and I said, well, it's a consensual confirmation, and the other person said, no, well, no, it's not. And I said, well, nobody's objected, yeah, but there's a class here that didn't vote, and I thought that was the craziest thing I'd ever heard, but that's the rule, right, as it stands, right?
And I think in part it's designed to make sure creditors aren't prejudiced if they decide not to vote, because that's a creditor right. When you get a ballot, you can decide to do nothing. Whether or not that's the right thing to do, I leave to creditors, lawyers, and their clients. And I do think it's important for the integrity of the system to make sure that we offer a path to 1191A plans that protects creditors in that route. Because again, I don't like the perception that although Subchapter 5 certainly, and I don't deny this, gives debtors more tools than they otherwise would have under a traditional Chapter 11, I don't like any kind of bankruptcy case where we are completely ignoring one party's rights. And so we have to recognize creditors have rights. They have rights under state law. Bankruptcy tries to respect those rights to the greatest extent possible. And it's just a matter of striking the right balance. So I'm hoping that Congress looks at the task force report here, because I think this is one place where we really tried to strike that balance, right? To think about both sides and just make it better for everyone.
Cool. So there's I don't know that we could call this making it better, but we got the eligibility limit. cap. And that's coming up here. It's going to expire on June 21, and go from 7.5 million back to like 3 million or something like that. What did the task force do on that?
So the task force came out actually early, prior to the final report, and recommended, based on an overwhelming amount of evidence, that Congress keep the debt cap at 7.5 million on a permanent basis. And I think the task force got there based on not only the qualitative evidence we had from testimony and written submissions, but also the quantitative data that was showing 7.1 for, or 7.5 for whatever reason, seems to be the right number. When you look at it, it accounts for about maybe over a third of all sub fives that file. So, if we take that limit back down, you're going to tell a third of these companies they don't have a path to reorganization, most likely, because an 11 is not going to do it for them in the traditional sense. And we also saw, and I thought this was really interesting, that when you get towards that $7.5 million debt point, those companies double their chances of reorganizing if they do a subchapter 5 versus a traditional 11. And so that, to me, kind of says we're at the right spot, right? That the tools in the subchapter are working for those companies and their creditors, particularly when you think about over 60% of all plans that are confirmed are consensual or 1191 plans where people have voted, right? Because we just talked about that. You have to be singing Kumbaya in order to get 1191 right now. And so because of all of that, the task force strongly encourages Congress to keep it at the $7.5 million debt cap on a permanent basis. Whether or not that will happen, I don't know. We'll know soon enough. It's almost June and almost June 21. I will say that going back to the certainty point, I just think we need to resolve this issue, because the uncertainty creates cost. It creates strategic decisions that may not be in the best interest of the company or its creditors. And I do worry a little bit about another gap as we had before, and what that means for companies who maybe are trying to stave off financial distress as long as possible, because oftentimes, particularly with small businesses, they do that, right? Bankruptcy is truly a last resort, and then they get to the point when they need it and it's no longer available. So that kind of uncertainty, I think, is problematic for the practice.
All right. Well, oh, by the way, I did some checking on this recently. So here's the chronology of how this debt limit thing worked out. So the subchapter 5 was enacted in like August of 2019. COVID hit, and at the end of that year, beginning of the next one, in February of 2020, subchapter 5 became effective with a debt limit of about 2.3 million. And all of a sudden, Congress realized, hey, we might have a lot of small to medium-sized businesses in trouble with COVID. And so the next month, they changed the cap from 2.3 to 7.5. And then that has been extended a couple of times, and then it's set to sunset at the end of June and go back to the 2.3, which adjusted for inflation gets us a little over 3. So that's what's pending right now.
Yep, absolutely. That's a great chronology. And I will say that I am glad that Congress was so proactive in response to the pandemic and what we all thought we might be dealing with in the bankruptcy courts. But I think our study with the task force through the American Bankruptcy Institute showed that the troubles facing small businesses are not just pandemic related, right? Small businesses have these kind of financial distress issues that really can be fatal for the business, even in non-pandemic times. And so keeping the subchapter available to them now, I think, is hugely important. And I will say, going back to the commission report, I think the commission recommended 10 million as the right cutoff for SMEs. And as you know, in the subchapter 5 task force, we heard some encouraged, let's go up to 10, let's go up to 15 million. I'm not, based on what we saw, and again, all my statements, I should say, are just purely academic and for educational purposes, but based on the data, I don't think we're in a place where we should raise it. but I think we're in the sweet spot right now, and why mess with it? It's working.
Well, on that fine note, Judge Harner, thank you very much for your time here and for your wisdom, and thank you for your efforts as the reporter on the commission and as the co-chair of the task force. Very much appreciated. Thank you.
No, thank you, and thank you, Don, for being a member of the task force. It was a great learning experience for all.
Yes, it was. Thank you very much.